So, Chapter 15, Legal Rights and Responsibilities. Law, set of rules that allow people to live together. Everyone knows of what is allowed and what is not. It keeps the peace and prevents violent acts. It sets punishments to discourage future crimes. Laws should be fair. They treat people equally under the law. They're understandable, and they are also enforceable. The Constitution is the nation's laws based on ideas, laws, traditions that date back thousands of years. Just some history of law. It's passed down orally, and then also later it was written down. Code of Hammurabi is the first set of laws that we know of, at least that was written. King Hammurabi of Babylonia, 1760 BC. There were some pretty harsh penalties for breaking the law. Then we know the, Ten Commandments, which would also be considered laws for the Jewish nation. Then we have Roman law, or the Justinian Code, named after Emperor Justinian. Romans had many laws. A lot of the consequences were harsh. In 533 AD, Emperor Justinian I, ruler of the Byzantine Empire, condensed the laws into a simpler list. This also addresses civil law, which are private matters. English law, Magna Carta, 1215, establishes common law, which is law based on court decisions rather than legal code. Judges look to precedents, which is how the first ruling went in a similar situation. Basic principles, trial by jury, and innocent until proven guilty. Parliament used statutes, which are written laws, and common law. U.S. Constitution, brought to the Americas by the English settlers in the 1600s and 1700s. Common law tradition, which again follows the precedent set by the court. The Napoleonic Code, adapted from the Justinian Code by Napoleon Bonaparte. Louisiana, once French territory, has state laws based on this code. Common law, again, customs and precedents, which are used to decide civil cases. Criminal law, sometimes called penal code, is enforced by government on local, state, or national levels. Civil law, disputes between parties enforced by private parties. Criminal law is the adversary system. Two sides argue the case out. This is the type of law you most often see on TV, at least in dramas. Critics say it encourages lawyers to ignore evidence that is not favorable to their side. Plaintiff in criminal cases is always the government. Defendant is the one accused of the crime. So, for example, State of North Carolina versus Robert Jones, or the people versus Robert Jones is what you'll see a lot of times in any kind of public case where it is a criminal trial. Felonies are misdemeanors. Felonies are murder, rape, arson, robbery, or any other serious crime. They usually carry much heavier consequences. Misdemeanors are vandalism, shoplifting. These are also less serious crimes. They're punished by fines or usually less than 1 year of jail time. Infractions. So infractions are like speeding, not wearing a seatbelt. Usually you get a ticket for these. Misdemeanors, you're leaving the scene, driving with and here's some examples of what would be misdemeanors are leaving the scene, driving without a driver's license, or driving without insurance. And then a felony would be like DUI, hit and run, or vehicular homicide. Crimes against property. These are the most common. Larceny, it's the unlawful taking with intent never to return it, basically stealing. Robbery, unlawful taking using force or threats. And then burglary is where you break in and then take. Civil law, no criminal cases have been broken, or no criminal laws have been broken. These disputes are not a threat to society. The lawsuit is filed, sued to collect damages. Person suing is the plaintiff. Person being sued is the defendant. Usually these are more personal matters or more private matters than criminal law. Criminal law tends to be more of a public matter. Civil cases, mail order does not arrive. Torts, person who suffers an injury because of someone else's negligence. Torts are what you see a lot of times in civil cases. For example, McDonald's coffee, property owners responsible for keeping sidewalks clear. You fall on ice on your neighbor's sidewalk, you have the right to sue. Family law, civil cases, involves divorce, child custody, adoption, alimony, child support, spousal, and child abuse. Battles for legal rights. Earliest case, John Peter Zenger case. Printed an article about corrupt governor in his paper. Zenger charged with libel, which is printed lies, found not guilty. Other types of law, constitutional law, deals with the formation, construction, and interpretations of constitutions, again on the national level and at the state level. Administrative law, the Federal Aviation Administration issues an order for safety device on airplanes. That would be administrative law. The executive branch would then have to carry it out and enforce this law. And then also statutory law. It's regulating behavior, speed limits, inspecting food products, getting driver's license, return merchandise. These are creating statutes or what we know at the state level as laws. So the American legal system, it's the Phoenix attorney with Miranda. If you remember Miranda v. Arizona, the Supreme Court case where we have our Miranda rights, you have the right to remain silent. Okay. Let's picture that court case. Protections in the U.S. Constitution, granted writ of habeas corpus. Basically, you have to be told what you're getting charged with and why you're being held in jail. The Fifth Amendment, grand jury hearing, double jeopardy, you have the right to remain silent. Sixth Amendment, informed of the accusation, question, hear witnesses represented by a lawyer, speedy and public trial by jury. And then the 14th Amendment, you have right to due process, equal protection under the law. Okay. So biases should be removed. Individual rights, courts base their rulings on written laws and precedents of earlier cases, rulings used for similar cases in the future. This process is called stare decisis. It's Latin for let the decision stand. Basic legal rights, you have the writ of habeas corpus, it's why you're being held. You have bills of attainder, which cannot punish a person accused of a crime without a trial. Basically your right to trial. Ex post facto laws cannot be enforced after the fact for an action that was not against the law when it was committed. For example, the recent law change from being able to smoke from 18 to 21. You can't go back a month before that law was passed to charge someone who bought cigarettes at 19 for buying something illegally because at the time that they bought it, it was legal. It's an ex post facto law. Guarantee of rights, Bill of Rights guarantees the freedoms of individuals. The due process of law, which are the 5th and 14th Amendments, government may not take our lives, liberty, or property, except according to the proper exercise of the law. So, for example, if I don't pay taxes on my property for 10 years, the government then could put my property up for auction, and the money that they make off of it would pay the taxes I owe them. Okay? So there are ways that they can take your property. Or, for example, if I commit a criminal act, then they can take part of my life by putting me in jail or my liberty. Okay? So again, there are examples to where we take this out. So there are provisions in our system for your life, liberty, or property to be taken by the government if you are to break the laws of that system. Legal responsibilities, Declaration of Independence, all men are created equal. All people are entitled to equal rights and treatment before the law. Guaranteed rights of those accused. You are presumed or believed to be innocent until proven guilty in a court of law. The case that we're going to use is OJ's because in the criminal case, he was found not guilty. Okay. In the civil case, he was found guilty and ordered to pay damages in the amount of $33.5 million. Okay. So here it was a public case, the People versus O.J. Simpson, and they found that he was not guilty of the murder. In the civil case, they found him guilty and was ordered to pay, basically this was between he and the family. And then he was ordered to pay $33.5 million to the families of the people who were murdered. Fourth Amendment protects citizens against unreasonable searches and seizures. Judge's authority, specifying the exact place and describing what the police are looking for. This is what happens when they have to go get a warrant. Must show probable cause, a good reason to search the home. Okay. They cannot just say, Judge, we want a warrant and not have any reason. That would, lead to the judge getting disbarred or being removed from his job. Search warrants. This is just a funny little cartoon. Farmer with the egg basket going around checking the chicken's eggs, and he says, I don't need a warrant. Mapp v. Ohio. This is the exclusionary rule. So what happens if you don't have a warrant? The police come and check your house, and they find something there that you're not supposed to have. If police gain evidence in a way that violates the Fourth Amendment, that evidence may not be used in a trial. So in this situation, their house was searched without a warrant, and they found some condemning evidence. But since they had not gotten a warrant, nor had they any reason to believe that anyone was under danger, like they didn't have a probable cause to enter the house, then they could not use any of the evidence they found inside the house. Fifth Amendment, no person shall be compelled in any criminal case to be a witness against himself. It's basically the right to remain silent. It also protects the accused person from double jeopardy, meaning you can't be tried for the same crime twice. So, for example, going back to the OJ trial, he can no longer be tried in a criminal court for murder, for those people's murders. So he'll never be able to, they'll never be able to bring that case up again. Miranda v. Arizona, we talked about this before. When you're getting arrested, this is what led to the whole you have the right to remain silent. Anything you say can will be used against you in court of law. If you cannot afford an attorney, one will be provided for you. Okay, Fifth Amendment, people accused of serious federal crimes must be brought before a grand jury to decide whether the government has enough evidence to bring them to trial. Grand jury is a group of 12 to 23 people. They hear evidence presented by a prosecutor, and then they decide, is it enough to proceed to trial? If it is, they proceed to trial and go with their charges. If it is not, then that's pretty much where it dies. Okay. Here's just a grand jury. This is an example. This one was actually 1935 and actually had the first black man in Alabama to serve on a grand jury. Sixth Amendment, right to be defended by a lawyer. Accused people must be informed of the nature and cause of the accusations against them and have the right to a speedy and public trial by an impartial jury. People who do not know anyone involved in the case. That's what impartial means. Like, you can't be partial to one side. Okay. Also means trials usually may not be closed to the public or the news media, which is why a lot of times you see these things on TV. So like here would be an example of a not impartial jury. This would be like partial. So you have the dogs, you have Michael Vick. So like if the dogs were judging Michael Vick, then this would be a partial jury because what he did was against dogs. You would want people who were not partial, who had no benefit or no negative consequences from this case to be sitting on the jury to then decide whatever evidence was presented to them. Plea bargains, defendant pleads guilty to a less serious crime in exchange for receiving a less severe penalty than he or she might receive at trial. A judge must agree to the bargain. Now, this happens quite a lot. A lot of times it saves time from the trial, saves a lot of people a lot of money, and then also it ensures that somebody is going to receive a penalty for the crime. Because there are times where things do go to trial, the evidence can be overwhelming, but the jury may not condemn the person, may not find them guilty, and so then the person walks free. You will see this happen quite a lot, especially if the prosecution feels like there's not 100% chance of the person getting convicted. Eighth Amendment outlaws cruel and unusual punishments, prohibits excessive bail. Bail bondsman makes a percentage of bail money and requires collateral. This is where you come down with bounty hunters, basically people who might pay their percentage of bail but then not pay the rest, or might pay their percentage of bail and they get found guilty but then not show up to court, so then the bounty hunters track them down and take them back to jail. Early systems of law, we went over this earlier. Code of Hammurabi is the first written set of laws that we have. Then we have Ten Commandments, then Roman law, then English law, then the U.S. Constitution. So here are some questions you should practice. What we've just gone over, the system of a blank law is based on court decisions rather than on legal code. Is it criminal, constitutional, administrative, or common? Excuse me. It is common. The system of civil law dealing with civil wrongs or blank has a long history. Torts, felonies, libels, or plaintiffs. By the way, you can pause these between so that way you can get some time and then unpause when you want to go to the next question or see the answer. And it is torts. Okay. Remember, these are like what we see in the civil law system. It just means that somebody's been wrong. A person charged with a crime and tried in court is the plaintiff, defendant, tort, or judge. Defendant. A blank is a negotiation between the prosecutor and defense attorney to avoid a trial. Verdict, due process of law, plea bargain, search warrant. That would be a plea bargain. On which of the following did the writers of the U.S. Constitution base the system of laws? Russian law, new laws they created, ancient laws passed down through generations, or warnings from King George? It would be ancient laws passed down through generations, such as common law. Okay. The oldest system of laws known in the modern world is the Justinian Code, Napoleonic Code, Roman Code, or Code of Hammurabi. Code of Hammurabi. A crime that is considered less serious and requires a short jail sentence is a misdemeanor, felony, plaintiff, or lawsuit. It's a misdemeanor. And that is it. See y'all later.